Greetings, family. Welcome to my YouTube channel. Once you have subscribed, I'm very grateful for that. And if you haven't subscribed, please do consider to subscribe. And please share the videos, also comment, and press the post notification bell so that when I upload, you get notified. Today, I'm going to discuss how to reverse default judgment. In our last video, we spoke about a default judgment and when judgment can be given in the absence of the defendant. That's when it is called default judgment. Now, today, the question that I want to address is whether it is possible for this default judgment to be reversed, or the other way that we can use to be set aside or to be rescinded. And the answer is yes. Once a person becomes aware that there is a default judgment issued against them by the court, they can make an application for rescission of the default judgment. Because you must remember that in most instances, the default judgment was issued in the absence of the defendant being the person complained about. It was issued in their absence, and there can be a valid reason why they did not appear. So if there are reasons that may satisfy the court, they can make an application for rescission for that judgment to be set aside, to be rescinded, or even to be varied. To be varied means that they can make an application for this default judgment to be altered or amended somehow, depending on the circumstances of the case. There will be instances where something did not go wrong, or maybe they did not respond on time. Maybe they were served in papers, but for one reason or another, they were not served in time. Because you must remember that in court, the timelines are very important. That is why even the rules of the court provides for what is called condonation, whereby there was an instance where you were supposed to file a response, because once there is an action against you or a case against you, you have to be able to file notice to defend, to say, yes, I'm aware that there's a notice of motion against me. I'm aware that there's a cause of action or a case against me. Immediately, you have to respond to say, I intend to defend this matter, which is called a notice to defend. And there are instances where, for one reason or another, a person does not reply or does not file this notice of intention to defend. And if there is a reason that will convince the court that it's not as if you were negligent, there's a valid reason, a reasonable reason, then you can approach the court to say, I'm applying for rescission or variation of that default judgment. So when the court, or before then, there are options that a person can utilize once they're aware of the default judgment. They can accept the default judgment because probably it's because they don't have a valid reason to oppose it anyway. So they can afford accept the judgment. If the court says pay somebody 10,000 or whatever, they can just go ahead and pay, because knowing very well that perhaps if they can apply for a rescission, as I've illustrated, it will be an exercise in futility. It will be a futile exercise. So they can accept the default judgment, or they can challenge it because they know that they have a strong case to challenge it, or they can settle the amount for less. And the other option is that they can pursue the debt relief. So those are the the options that they have. Now, the most important thing that I need to mention here is that once the defendant becomes aware of this default judgment, because now we are assuming that he was not aware that there are papers or that there is an action that has been lodged against them. As soon as they become aware, within 20 days, the rule says within 20 days of becoming aware of the default judgment. You know, you can be aware maybe after 6 months, or maybe after 4 months, or after 5 months. You should be able to prove to the court that all along I was not aware. It's only now that I am becoming aware. And as soon as you become aware, within 20 days, you must act and make that application. Obviously, you will inform your attorney, and your attorney would begin to make investigations and prepare for a proper application, whether it's going to be variation or whether it's going to be rescission or whatever, maybe advise you somehow. So they need to promptly react, as much as you are also expected to promptly react within those 20 days once you become aware. So once the court is satisfied with your reasons for the application for this rescission, or this cancellation of this, or this setting aside of this default judgment, the default judgment will be set aside. And now it means that the matter will start from the beginning, or it will start afresh. It will be as if there was never a default judgment against you. So it means that at that time now you are given an opportunity to properly respond. So you are given time to respond to this claim against you, and the court order on the default judgment may be disregarded, depending on your reasons, of course. The fact that you are making an application for rescission or for cancellation or for variation of this default judgment does not mean that automatically it will be granted. This will depend entirely on your reasons for the application, why you were not present in the first place. So in other words, each case will be treated according to its merits. It's not automatic that it will be granted to you. So I hope this resolves or answers the question whether this default judgment can be cancelled. It can be cancelled. Just take those steps within 20 days. As soon as you are aware, the court will give you a hearing. The court will take a decision based on your grounds or the reasons that you will submit to the court. I thank you. Please do not forget to subscribe, to comment. Let's meet on the comment section. You know, that's how we do it in the YouTube world. We talk in the comment section. Thank you very much. God bless you.